we're recording.
Minimize this.
Minimize that. Call full screen.
Yes.
I don't foresee any issue, but there is an issue. You can contact us.
Professor LaPiana, you have about 5 minutes before everybody's coming back from a break.
Very good.
It technically couldn't be
If there's an issue, just contact us at 4417.
Okay.
So that works fine. Good.
And then you'll be in about 5:10 to shut it all down, because I mean,
Yes. We'll be here. We are.
thank you.
You're welcome.
Is that Jesse's MD?
I'm gonna keep him on my wrist.
That's what I'm thinking.
You're looking good.
Thank you.
Hey, we really appreciate you doing this.
I'm very, very happy to. Believe me.
It's going to be exciting.
Isn't technology wonderful?
It is indeed. Hopefully it'll all work.
Yes. Let's not jinx it.
Very good. All right, we'll let you get ready.
Okay.
Bill,
Yes.
happy early birthday.
Oh, thank you.
All right, welcome back, everyone. As you can see, we have Professor Bill LaPiana with us from New York via Skype. We're very grateful for him accommodating our technology, and we're very sad he won't be here, but I'm glad that this still worked out. Professor LaPiana is the Rita and Joseph Solomon Professor of Wills, Trusts, and Estates, as well as the Director of Estate Planning Studies in the Graduate Tax Program at New York Law School. Professor LaPiana holds both a PhD in history and a JD from Harvard, where he also received his bachelor's and his master's. After graduating from Harvard Law School in 1978, Professor LaPiana spent 4 years as an associate at Davis Polk and Wardwell in New York. Professor LaPiana is the author of several articles on estate planning, numerous articles in American legal history, and has authored several books. He's also been active in the Trust and Estate section of both the New York State and the American Bar Associations. In 1992, he was elected the Academic Fellow of the American College of Trust and Estate Council and is a member of the Board of Directors of the ACTEC Foundation for a 3-year term ending this year. Personally, Professor LaPiana has been a fantastic supporter of the EPJ, and we're very honored that he helps us. He's actually authoring an article that will be published this spring as well in Volume 7, Book 2. Professor LaPiana's presentation today is titled Same-Sex Estate Planning After the SCOTUS Decisions. Please give a warm welcome to Professor William LaPiana.
Thank you, everyone, and thank you, Evan, for that kind introduction. I'm very glad to have this opportunity to deliver this talk, even if I can't be there and meet you in person or go to last night's party or tonight's dinner. But that's the joys of travel in a truly horrific winter. When Evan Johnston asked me to reprise my talk of last year on the state of same-sex marriage and planning for same-sex married couples in non-recognition states, I was very pleased, but I did wonder what I'd be talking about given the speed of developments. Over the summer, as you know, every court of appeal, circuit court that considered appeals from federal district court decisions holding bans on same-sex marriage unconstitutional affirmed those decisions. The Supreme Court refused to issue stays of the circuit court's mandates. Justice Kennedy did briefly stay a Ninth Circuit mandate with reference to Idaho, but then the full court overrode him. And then on October 6th of last year, the Supreme Court denied certiorari in cases from the 4th, 7th, 9th, and 10th Circuits. And I thought my topic is over, although it certainly is not, as we'll see, no matter what happens this spring. And this spring was significant because on January 16th, the United States Supreme Court did issue cert in the Sixth Circuit case of Burke v. Beshear, which is the only circuit court to reverse district court holdings that a ban on same-sex marriage violates equal protection. Arguments are scheduled at the end of April, I believe on the 28th, and if past pattern holds, there will be a decision at the very end of the term, sometime at the beginning of June. Arguments will be presented on the two questions set out by the court, which are on pages 19 and 20 of the outline. They involve allowing same-sex couples to marry and recognition of valid marriages. That might not be overly significant because some of the cases involved the plaintiffs were asking only for recognition by their state of residence, not for the right to actually marry there. So we'll see how this turns out. And no matter what the High Court decides, there will still be many questions to answer. We'll start with a quick review of the state of the law, followed by a similarly quick review of developments in federal administrative practice, and then turn to questions that remain no matter what the United States Supreme Court does, drafting for exclusion or inclusion, and the question of private as opposed to governmental recognition of same-sex marriages. Now, the most dramatic development since I gave this talk 1 year and 1 day ago is in the number of states where same-sex marriages may validly be entered into. Last year's outline counted 17, plus the District of Columbia. The outline you have before you on pages 2 to 15 counts 36 states, plus the District of Columbia. And since the outline was prepared, we have to add Alabama, sort of. The dispute in Alabama is unique. No state judiciary has gone to the lengths that the Supreme Court of Alabama has to delay the implementation of federal court orders. Again, that was a typical pattern. The federal district court issued a preliminary injunction ordering the Attorney General and the governor not to enforce the ban on same-sex marriage. The Fifth Circuit refused a stay. The United States Supreme Court refused a stay, as it has all along, and as it also has with Justices Scalia and Thomas dissenting, but only Justices Scalia and Thomas. But then, as I'm sure if you followed in the news, the imbroglio started, and right now the state of things in Alabama is, well, confused. Marriage would have begun in Nebraska on Monday, but there the Eighth Circuit did stay the district court's preliminary injunction, ordering the law not to be enforced, and scheduled argument on that case and on 3 other cases, South Dakota, Arkansas, and Missouri, for May 12th, which is after the United States Supreme Court arguments in Burke, but almost certainly before a decision in that case. So we'll see what happens. Now, as I've said, the great increase in the number of jurisdictions recognizing same-sex marriage and allowing them to be contracted comes solely, since last year, from federal court decisions. Of the more than 40 federal district court decisions on this topic, all but 2 have struck down bans on same-sex marriage as violations of the equal protection guarantees of the 14th Amendment. And again, as I said, the circuit courts of appeal have refused to stay those decisions pending appeal, and the United States Supreme Court has refused to stay them. So that's where we stand. Now, since last year, there are 2 really significant federal administrative actions in this area. Probably the most dramatic is the Social Security Administration's decision to recognize as marriages all kinds of marriage equivalents, registered domestic partnerships, civil unions, reciprocal beneficiary designations, so long as they grant intestacy rights as a spouse to the surviving partner. Now, this comports perfectly with the governing statute that's also set out there, pages 26 and 27. Because under the Social Security statute, status as a family member in the first instance depends on the intestacy law of the state in which the parties reside. That's the statute which is behind Asture v. Caparo, which in May of 2012 led the Supreme Court to decide the question of the status of posthumous children is to be decided by the intestacy law of the state where the claimant resides. That's why New York changed its law this past year to allow posthumously conceived children under some circumstances to be heirs in intestacy, thereby qualifying for Social Security benefits. So this now follows what the statute really says. And it removes an issue that looked like last year would be terrifically important. Every state that had a marriage equivalent now has marriage. And you can see in the discussion, the state-by-state discussion, that they've handled the transition from civil union or domestic partnership to marriage differently. And for a while, it seemed that, boy, those differences would be significant, because if length of the marriage has any importance for Social Security claims, as it does in some circumstances, when your marriage really started could be important, and maybe it would be determined by these state transition rules. But now that Social Security will recognize marriage equivalence, so long as they grant inheritance rights, that question goes away, and academics have something less to write about. Appendix A has the chart from the Social Security Administration of all these marriage equivalents, whether or not they qualify, when they started, their usual lovely compilation of information, which is the twin to the corresponding chart on actual recognition of same-sex marriage. So that's one really important thing. It also has one odd little effect. The state of Washington had civil unions, they were phased out, they transitioned to marriage, except, although no civil unions in the future, but existing civil unions where one of the parties was 62 or older would not be automatically transformed into marriage. Presumably, that was done in order to prevent adverse Social Security effects. If two people are collecting Social Security, if they marry, their overall benefit might go down. So, well, let's preserve that civil union because they're not married. Well, they are now. And that attempt to prevent an adverse effect on your economic well-being, or a possible one from marriage, is now gone. Now, a couple of weeks ago, the Department of Labor issued final regulations on the Family Medical Leave Act. And the outline tells you that Family Medical Leave Act questions of spousal status were to be determined by the state of residence, no longer. These regs will be published on March 25th in the Federal Register and will become effective 30 days later. And they will say, they do say, that for Family Medical Leave Act purposes, one is a spouse if one has been legally married, where the marriage was entered into, the place of celebration standard that the outline talks about. And this was done, and I quote, to ensure that all legally married couples, whether opposite sex or same sex, will have consistent federal family leave rights regardless of where they live. It is a very long, totally thought out regulation, lots of stuff on how they came to this, the responses they got from their rulemaking processes. But at least starting 30 days from March 25th, that will be the rule. Doesn't change anything else about the Family Medical Leave Act, about the size of employers, how many employees you have to grant those certain rights, but that will be the rule going forward. Now, how much of this could or might change, no matter if the Supreme Court does not reverse the Sixth Circuit case and allows the states, to make the decision about whether or not to recognize same-sex marriage or to allow same-sex couples to marry? Might an administration not as favorable towards same-sex marriage change this? Well, I suppose one answer is yes, but practically probably not possible. There would be enormous confusion and probably an enormous outcry. So I think we can assume that even if the United States Supreme Court does not reverse the Sixth Circuit, that these administrative decisions will stand. Same-sex married couples will continue to be treated for federal tax purposes as married no matter where they live. They will be treated as married for Social Security purposes depending on where they live. And I've got all the stuff in the outline. It's exactly where you live when is important. If same-sex marriage does not become nationwide, just don't let any of us who have clients in a state where they are legally married, don't let them move to a state where they're not recognized before they file for their Social Security benefits as a married couple. But otherwise, most of this, I think, will remain exactly the same. And with the Department of Labor using place of celebration standard for FMLA purposes, that pretty much just leaves the Department of Defense and Veterans benefits dependent on state of residence. One wonders how long that might last. But there is a statutory reason for that, and I don't think we can expect the federal statute to change anytime soon. One of the topics on which there has not been much development is divorce, which is described in the outline. The Texas cases that were pending last year still are pending. As far as I can tell, there is no decision, and maybe after this June it won't matter what decision is made. I commend the divorce stuff to you. If you do have same-sex married couple, validly married, where the marriage was contracted, living in Texas, they want to separate, there are problems, as I'm sure you know. And the outline does try to describe those states which will divorce same-sex married couples married in that state, even if they don't fulfill the usual residency requirements. Some of them are more favorable than others, and that's discussed. The one thing you don't want to do, of course, is to allow them to marry in California, where when they divorce, they will face this concept of quasi-community property, which means everything they accumulated during the marriage is treated as community property, even if it wasn't where they were resident while the marriage was going on, which is presumably a provision that on the whole benefits forensic accountants more than anyone else. There are better choices for that. Now, something I didn't talk about much last time is the drafting questions that this pattern of recognition and non-recognition raises. And I talk about that in the outline, and I want to spend a little time with that. And that's at about page 48. I apologize for jumping around, but like this topic, this outline has grown organically, and it doesn't quite fit sometimes the organization of the best way to talk about it. But this actually starts on page 46. If we think about how we draft wills, they depend enormously on family relationships. You talk about spouse, you talk about children, you talk about descendants. And as I'm fond of telling my students, when I was sworn into the New York bar 35 years ago last month, what those terms meant was a lot clearer than it is today. Then, all right, adoption. And even then in New York and in most of the United States, to be adopted in meant you were fully in the family. You were a grandchild, a niece, a nephew, stranger to the adoption rule, long gone. And if you wanted to exclude adopted people in your documents, you had to say so. Similarly, spouse was spouse. You were either married or divorced. Okay, there were some fancy things, like in New York, judicial separation is the equivalent to divorce. That's a historical remnant of what our divorce laws used to be in this state, but generally we were pretty sure. In the subsequent 35 years, what's happened is same-sex couples can marry now in 30-some-odd states in the District of Columbia. Children can be born without sexual intercourse through assisted reproductive techniques, and not only artificial insemination, which is actually fairly old, even in a human context, but through in vitro fertilization. And children are born now after the death of one of their genetic parents, and sooner or later it may be after the death of both. Not even born, but conceived. Gestational surrogacy is not only possible, but depending on what statistics you believe, fairly widely used. So what do these terms mean in our documents? And what do they mean if they mean one thing in the state where the testator is domiciled and expects to die, and another thing in the state where they end up being domiciled at death, or where ancillary probate has to happen because they have real estate in that state? And I know, talking to an audience in Texas, believe me, one of the nastiest things I discovered as a baby associate was someone who had all these itty-bitty little oil and gas royalty interests, and I mean itty-bitty, and I had real property all over the country, and it was exceedingly unpleasant. Fortunately, most states have some easy way to handle this, but ancillary probate, your will's got to work under the law of that state. So, starting on page 48, I hypothesize this. I am married to X, and all the references in this will to my spouse are to X. Now, how many people have written wills like that, right? Define who the spouse is. Well, that might work in New York. My will says I'm married to Sebastian, which I am, and all references in this will to my spouse are to Sebastian Gluck. What if I own real property in Texas, and when I die, didn't turn it into non-probate property, which I should have, particularly since I teach wills and trust law, I better. But let's say I didn't. And my will is brought to probate in Texas, and non-recognition is still the rule. That makes no sense in Texas, because Texas statutes and the Constitution say marriage doesn't exist between two people of the same sex, and you can't recognize any legal status identical or similar to marriage. So that will is an impossibility. At the very least, it's some kind of crazy ambiguity. Since his name is unquestionably a male's first name, is it patently ambiguous? If he has an ambiguous first name like Terry, is it latently ambiguous? I don't know. And of course, who cares? Because the extrinsic evidence will show you he's male and married to a male, therefore there's no marriage. So maybe the whole gift collapses. I don't know. Now, obviously, the thing to do is to draft so that doesn't happen. So maybe it simply says, I'm married to name. I don't like that one so much. What I like is what I cooked up on page 49. I give the rest, residue, and remainder of my estate, both real and personal, wherever situated, to the person, if he shall survive me, and if he does not. No reference to status. Or I am married to person. In this will or trust, references to my spouse are to this person, whether or not our marriage is recognized in the jurisdiction which the terms of this will or trust are to be effective or carried out, or where this will is to be admitted to probate. Presumably that will do it. We have great ability to define what the terms in our documents mean, and I assume that's how one would want to do it. There's an even bigger question when you're talking about children. Okay, we can deal with non-marital children. We can deal with adopteds. Maybe you write them in or out, but if we're talking about the testator's own will, their own adopted children, highly unlikely. But remember, one of the oldest presumptions of the common law is that a child born within marriage is a child of the spouses. Fine. Even in New York today, the court can only order a genetic test on husband to see whether or not he is really the father of wife's child, if it is unquestionably in the best interests of the child. Otherwise, it's just not to be done. Now, what happens when a woman married to another woman gives birth? Without more, is that child her spouse's child? Well, we have a court in New York, a surrogates court in Kings County, just on the other side of the river, that said, so much is that true now that we won't let the non-birth mother adopt the child, because they're already the parent, even though they may end up in a jurisdiction where the parentage created through the marriage isn't recognized because the marriage isn't recognized. And the opinion says, I realize this may cause problems, but that's the principle. If I were the parents involved in that, I would not feel so good about that. We do have a case in upstate New York now in a family court which says that's not the case, although it's exceptional. Yes, it was one woman married to another, and yes, she did give birth, one of them during the course of the marriage, but everybody agrees that the child was conceived through sexual intercourse outside of marriage with a man. So that makes it more difficult to say her spouse is the other parent. These are tough questions, and maybe you can draft around it. I have some suggestions on 50 at the bottom of 50. On 51, it's even tougher for a male couple where they can have their child only through the use of a gestational surrogate. You need a state where gestational surrogacy is possible. And it is not possible in New York, and I have a reference here on 51 to Matter of Doe, where the surrogate did recognize California proceedings that make the child conceived through and born through gestational surrogacy to affirm that child's parentage on the part of the couple that started this arrangement going. But again, those are more really difficult open questions. Even more difficult, perhaps, starting on page 52, are what do you do in the documents of third persons who don't want same-sex spouses of their descendants counted as spouses, or who do or do not want the children of their descendant same-sex spouse, who are the children of their descendant in the jurisdiction in which everybody lives, counted as their descendants. That's going to require, obviously, drafting around it. And that's on 52 and 53. And I just commend the language to you as at least a place to start. What about gifts conditioned on marriage? There are wills that say, you're not going to get what I'm giving you unless you're married to describe however the right person is supposed to be. The latest one is the Feinberg case in Illinois, where benefits, being a beneficiary under a trust, was conditioned on not being married to someone who wasn't Jewish, because the creator of the trust, the family, was Jewish. The Illinois Supreme Court, in a very narrow opinion, it's described on 54 and 55, held that that restriction was okay. But the opinion's written in such a way that it really only applies to this case. It's one of those opinions that starts with big ideas and gets narrowed down so you get everyone to sign on to it. That's how it reads. Now, whether you get the gift only if you do not marry someone of the same sex, I don't know. Maybe. Certainly, you get your gift only if you divorce your same-sex spouse. Probably isn't going to work if we're in a jurisdiction where the marriage is possible to begin with, because one of the things that's always contrary to public policy is encouraging divorce. So there's stuff in here on 56 and 57 about this. It's eventually some case like this will come to a test in the courts, and we will see how it turns out. I do, on pages 58 and 59, talk a little about a topic that certainly there will be more of, and that is, how do we construe the meaning of spouse in existing documents and wills and trusts that were executed long before same-sex marriage was possible? And think of the long-term trust, which generally makes some provision for a beneficiary spouse, at least allows them to appoint income to them if your beneficiary dies before their spouse. Always a good idea to prevent them from, in desperation, trying to adopt their spouse, which is where most of those cases come from. It's hard to know. You know, once upon a time, issue would not include adopted people, at least in some states, if the document was old enough. Questionable whether that's true in New York, which is the only law I'm truly up to date on. And that's because, all right, adoption was a way of creating parentage that was unknown to the common law, only comes through statutes. Spouse is spouse. But this is a kind of marriage that 25 years ago no one would ever thought would be possible. It's going to be difficult decisions. And again, it's going to come before the court sooner or later. Impossible to predict how it will come out, I think. A lot will depend on what the Supreme Court does when its opinion comes down, almost certainly in June. But those are more open questions we'll have to face. Now, I want to, in my last bit of this talk, address something that is now two things that are going to be real issues if the Supreme Court does hold that to deny a marriage license to a same-sex couple violates the equal protection guarantee of the 14th Amendment. The first are problems of transition. Let's assume you have clients, a same-sex couple, who are among the very first out-of-state couples to marry in Massachusetts. They then immediately came home to Texas, where they've lived ever since. They have been married now for 10 years. After June, that marriage has to be recognized in the state of their domicile. When did they start to accumulate community property? From when the marriage was recognized, or when it took place? Now, you could look at this as a question of the retroactivity of a hypothesized Supreme Court decision. One way to look at this is, if it was unconstitutional, it's unconstitutional. It never was. Now, that works well for some statutes, not for others. It's difficult to deal with that in this context. Now, the federal government, at least the Treasury, has taken a relatively pragmatic view of this, because one of the federal administrative things that happened that I sort of glossed over at the beginning is Notice 2014-15, I think it is. 2014-19 on page 23. This was Treasury's pronouncement on when qualified plans subject to ERISA have to treat spouse as including all validly married spouses, same sex or not, wherever they live. And what the notice says is that that must be the case from the date of the decision in United States v. Windsor going forward. And you have to amend your plan to say that if it says anything contrary. And that then there was a further notice that's mentioned on how you make those mid-year amendments. I leave that to the employment benefits lawyers to get into the real details of that. Now, the notice did say that, sure, you can treat as a spouse a validly married same-sex spouse for the period before the Windsor decision, but it's optional. You can make amendments to your plan to do that. And then it notes what might be a great understatement that the practical difficulties might be daunting. So, we've actually been married for 10 years. Should have been a qualified joint and survivor annuity. Or the employee died 5 years ago. That should have been a qualified joint and survivor annuity. Where's my money for the last 5 years? Where's that money going to come from? If they've always been, how are you going to get money back or add money? A lot of pension plans don't have much of a margin to work on. It's administratively extraordinarily difficult. And it's quite clear for these purposes that the IRS does not consider Windsor to, in that sense, be retroactive. And maybe that'll be a case with the hypothesized opinion holding that same-sex marriage is required by the Equal Protection Clause. If it's not, that is, if it's not, has to be, does not have to be backward-looking, retroactive, then it may be up to the states to deal with their statutes to try to sort this out. And I know there's an effort trying to do that in one of the states that figures it's going to face transition issues. The Bar Association is actively thinking about this. And again, maybe for practical purposes, and particularly for security of title, might be easier if it's at all possible to say, okay, the community property starts from the date of the decision that says it must be. Because, and I think I've got this right, because I come from a common law state, but this is my nightmare scenario, and Jerry Byer can tell me whether I'm right or not. The same-sex married couple married in Massachusetts always lived in Texas. One of them takes what would be community property funds, had they been married, and buys real estate for investment. The investment turns out really well, and they sell it. And of course, who's the only name on the deed as grantor? The person whose name is on the deed when it was conveyed in. Except they're married, but the marriage isn't recognized, so I guess the other person's got nothing to do with this. If we retroactively recognize the marriage, is the title bad? Does it have to be somehow ratified by the spouse who suddenly we look back and that was community property? I don't know. I do know they're worried about this in Florida with regard to homestead under Florida law, which of course creates something in the spouse no matter whose name it's in. It's a real problem. Worried about that. I think one should be. It's easier here in New York. One of the great things about a common law state without a homestead law of any kind is that you own what you own. And when death comes, if your spouse's rights comes through the elective share statute. If we have to go back and trace and fix things, we're almost going to go back to a world where the spouse had inchoate dower, the land went away, and then 25 years later, the spouse is knocking on your door asking for their one life estate in 1/3 because they didn't release their dower when you conveyed the land. So these are going to be extraordinarily difficult problems that we'll have to sort out. Now, the other thing one might think about, but maybe far less important, is making all of the statutes up to date. In New York, we have had same-sex marriage by statute since the passage of the Marriage Equality Act in 2011. We have not updated our statutes at all. Still talks about the paternal and the maternal line in our intestacy statute. We have a statute that says real property conveyed to a man and woman described as husband and wife is held by tenants by the entireties unless the deed says otherwise. We all know that applies to any married couple because the legislation enacting marriage equality says that it's equality for all purposes under all statutes and rules of law and decisional law. So maybe making the statutes catch up is not as important, but some of these transitions issues really, really will be. That's something to think about for the future. Now, the last thing I wanted to talk a little about is on page 33 of the outline. And this is going to become, I think, more and more significant. As we know, although sometimes we don't think about it, even as lawyers, as often as we should, that the 14th Amendment operates on government, on states. There is no violation of equal protection unless there is state action. Shelley v. Kramer, right? The covenant, the deed saying you couldn't sell to someone who was not Caucasian could not stand because a court would have to enforce it. That's state action. Okay, fine. How much private refusal to recognize marriage between same-sex couples will remain or can remain absent statutory changes at the federal level, should the Supreme Court decide the way most people think it will? You know, private racial discrimination was something that the Civil Rights Act had to be passed to deal with. So, with that in mind, take a look at page 33 to Roe v. Empire Blue Cross Blue Shield. Plaintiff's employer's health insurance plan expressly excluded same-sex spouses from spousal benefits. So plaintiff was denied coverage for her same-sex spouse under the health plan. The person she married after same-sex marriage was legalized by statute in New York. Not just recognizing from out of state, but actually to get a marriage license in the state and get married. The plaintiff sued and claimed discrimination and a breach of fiduciary duty under ERISA. The district court dismissed the suit, and the Second Circuit affirmed because the plaintiff failed to allege any right under the plan with respect to which the employer had discriminated, and because the plaintiff had not adequately alleged any breach of fiduciary duty. Now, obviously, okay, that's kind of a hint. Maybe you could have done a better job of figuring out a fiduciary duty breach, but there wasn't in this complaint. And then the district court distinguished the previous case in the outline on 33, Cozen O'Connor v. Tobitz, because in that pension case, pension benefits plan case, the benefits, the default beneficiary was the spouse. The decedent, who was a partner in Cozen O'Connor, had married her, was in a civil union with her same-sex spouse in Illinois. When she died, the question was, is the spouse a spouse for purpose of being the default beneficiary under the benefit plan, or is it the next default beneficiary, the parents? Now, an Illinois court had said they were spouses for all purposes. And there, the Eastern District of Pennsylvania court, that's where Cozen O'Connor is in Philly, had no trouble, really, saying that, yes, the surviving spouse, partner in the civil union, is the spouse, end of discussion, default beneficiary. The district court in Roe says that that's different because there was no definition of spouse in the plan. In the health benefit plan at issue in this case, spouse was defined to exclude same-sex spouses. And that's enough to distinguish the cases. Now, the district court said, and the Second Circuit agreed, that the opinion, quote, does not address whether the plan exclusion is constitutional or otherwise lawful under any other federal or state laws. Now, That opens up, of course, an enormous range of questions that certainly will be litigated in the years to come. Even if the Supreme Court decides same-sex marriage does not have to be nationwide, because this one, of course, is occurring in a state where same-sex marriage has been not only recognized, but perfectly able to be entered into. That's awkward. But you can contract the same-sex marriage in this state, and you have now for almost 4 years. So these are questions that are going to be of enormous import. It's going to create lots of constitutional litigation in the years to come. And will, although I think we will find ourselves in a situation in which legal rights, in the sense of rights that come from the polity, the intestacy law, elective share, community property, who's a parent, all those things will proceed treating all marriages the same. The question is, what about private action to which which is clearly not state action? Now, in this employment benefit case, again, I don't know enough about employment benefit law to be very confident in talking glibly about it, of course, which has never stopped a law professor ever. But I do think that I wonder what the relationship is between the Treasury's promulgation about qualified plans under ERISA, which I take mainly to mean those pension plans, the 401k and the equivalents like my 403b, and all government plans, it says, are covered, that must treat spouse as spouse, no matter of what sex the spouses are, and things like this health insurance plan at issue in this case here in New York, or other possible employment benefits. So we'll see how that one plays out. You know, Cozen O'Connor, on one hand, when it was decided, was considered quite a triumph for legalization of same-sex relationships, but the courts had no trouble, rightly, I think, distinguishing it in the subsequent case. So we'll see how that plays itself out in the future. I also want to note that Thunberg, on page 34, which was extraordinarily significant when it was decided, because there was the Ninth Circuit saying that a marriage equivalent in Oregon, which since of course has same-sex marriage, should be for federal employment benefit purposes the same as a marriage. So much of that now has been superseded by the Social Security Department's actions. I think we will find that transition will become less important. And of course, every state that had marriage equivalents now has marriage. So that issue is just going to go away. And if this outline has more evolution, that part will probably drop out. I have just about finished my time. I hope you have found this both informative and, like so many talks, I'm afraid, raising more questions than it can possibly answer. I don't know whether the technology will allow me to take questions in the couple of minutes that are left, but I'm happy to do so if we can.
Ask us, we'll ask him. How about that? Is there a microphone?
Jerry. Bill, this is Jerry. Yes, they can ask questions, and they're getting the microphone to pass around right now.
Great.
Handheld one. Hello? Can you hear
Hi,
me?
I can hear you perfectly.
Wonderful. All right. Does anyone have any questions for Professor LaPiana? I don't think so, actually. So I'll let you.
Professor LaPiana, I guess you did that good of a job explaining things because we don't have any questions for you. But we thank you very much for taking the time to do this and for attempting to try and get out here the other day.
I'm only sorry that I can't be there in person, and I'm very happy to be able to do this, and thank you.
Perfect.
for
Thank
asking.
you very much, and have a great weekend.
Thanks again, Bill.
Thank you.